On 9 April 2024, the European Court of Human Rights ruled that Switzerland's climate action framework had failed the claim of senior and applicants under Article 8. Yet the hardest moral question raised by climate change concerns not those Swiss women facing heatwaves now, but people whose very identities may depend on what we decide today. The case was Währung Klimasenioren in Schweiz and others versus Switzerland, decided by the court's Grand Chamber. The applicants were Swiss women concerned about the health risks of heatwaves. They were not legal representatives appointed for future persons. Their claim concerned living people, present danger, and an existing rights framework. That matters because law usually works most clearly when it can identify someone who has been wronged. A person has a right. An institution fails in its duty. The person suffers the consequence. Climate change fits this pattern in many cases. Heat waves already threaten health. Environmental danger is already escalating. Courts can examine whether governments have provided adequate protection. But climate policy also reaches much further. It shapes the conditions under which later people will live. It may shape where families live, when people have children, and which people come to exist at all. That last point changes the moral structure of the problem. Derek Parfit set out this challenge in Reasons and Persons, published in 1984. He called it the non-identity problem. The basic thought is unsettlingly simple. Decisions made now can affect not only how well future people live, but which future people exist. If a different policy would have led to different people being born, then a future person harmed by the policy cannot straightforwardly say that the alternative policy would have been better for them. Under that alternative, they might never have existed. This does not mean climate harm disappears. It means one familiar way of proving harm becomes unstable. We often say that a policy wrongs future generations because it leaves them worse off than they otherwise would have been. Parfit asks, worse off than what exactly, if the people living under the alternative policy would not have been the same people? The strongest objection to treating future welfare as morally secondary will appear later, in Seana Shiffrin's argument about imposed serious burdens. But first we need the older moral framework that made concern for future people seem not only possible, but required. Henry Sidgwick's impartial view of welfare. Henry Sidgwick developed his utilitarian ethics in the Methods of Ethics, first published in 1874. His central demand was impartiality. From an impartial standpoint, one person's good is not intrinsically more important than another's. The moral point of view does not automatically give special weight to welfare merely because it is mine, yours, or close to us in time. This framework includes future welfare. Sidgwick did not formulate Parfit's non-identity problem, but his basic moral orientation has an obvious consequence. The fact that someone will live later does not by itself make their good less important. Present people do not receive a moral discount simply because they happen to be present. This is one reason climate change appears, at first, morally clear. If current choices create serious burdens for later people, then later welfare belongs in our reasoning. We cannot simply count the benefits available now and ignore the cost that will fall later. A policy that protects present convenience while leaving later lives substantially worse seems hard to defend from an impartial standpoint. Intergenerational policy, however, is not merely a matter of transferring benefits and burdens between fixed groups. It concerns people whose existence and circumstances depend on earlier collective decisions. Climate policy is part of that structure. Different collective choices can alter the social and environmental circumstances in which future people come to exist. Sidgwick's impartiality still tells us something important. It tells us not to treat future welfare as morally invisible, but it does not yet tell us how to describe the wrong when the people affected by one policy may not exist under another. We need Parfit's depletion case, where conserving resources and consuming them produce different futures and potentially different people. In Reasons and Persons, Parfit introduces the non-identity problem through several choices, including the depletion example. The case begins with a policy choice about resources. One policy conserves them, another consumes them, leaving later generations worse off. The ordinary verdict seems immediate: conservation is better. A society should not use resources in a way that burdens later generations when it could instead preserve more for them. This sounds like a direct duty owed to those who come after us. Then Parfit adds the crucial complication. Different policies can predictably lead to different people existing in the future. A change in collective policy can alter later circumstances. Those altered circumstances can influence the chains of decisions through which future people are born. The people living in the depleted future may therefore not be the people who would have lived in the conserving future. Now consider a person-affecting view. A person-affecting view judges an outcome primarily by whether it is worse for particular people. On that view, moral harm has a familiar shape. Someone is worse off than they would otherwise have been. But the future person in the depleted world faces a strange comparison. The conserving policy may indeed have created a better world, yet it may not have created a better world for that particular person. Had the conserving policy been adopted, a different person might have existed instead. The person living under depletion may have a life worth living, even though their world is worse than the world that conservation would have produced. This is the non-identity problem. It does not show that depletion is good. It shows that one standard argument against depletion may fail. We cannot simply say that the policy harmed particular future people by making their lives worse than they otherwise would have been, because the relevant alternative may have contained different people. Climate change makes this more than a philosophical puzzle. A climate policy can shape long-term environmental conditions. It can also shape the social circumstances in which later people exist. If moral wrong requires a person who can say, "I would have been better off under the alternative," then some long-range climate harms become difficult to state. But there is a problem with this argument. It can sound as though a life that is beneficial overall settles every complaint about the burdens imposed on the person living it. Seana Shiffrin challenges that inference directly, while David Heyd raises the opposite concern about claims made on behalf of merely possible people. David Heyd examines ethical problems of creating future people in Genethics, published in 1992. His concern is that decisions about who will exist differ from ordinary decisions affecting already existing individuals. This is an important restraint on easy moral language. A person who does not yet exist is not simply another current rights holder waiting outside the room. Ordinary claims often involve an identifiable individual. Someone exists. A decision affects them. They can be helped, burdened, protected, or wronged. Decisions about future existence are different because they can determine whether there is anyone there to bear the claim at all. Heyd's point gives force to the non-identity problem. We should hesitate before treating merely possible people as though they held ordinary claims in precisely the same way as existing individuals. If a policy changes who will exist, then the moral relation between decision maker and future person does not fit the standard model of injury. But Seana Shiffrin presses back against the conclusion many readers attempted to draw. In Wrongful Life, Procreative Responsibility, and the Significance of Harm, published in 1999, she argues that causing serious burdens can be morally troubling even when existence is beneficial overall. The target is a quick inference. If someone's life is worth living, then the decision that led to their existence cannot be the object of a serious moral complaint. Shiffrin challenges that move. A worthwhile life does not automatically erase the significance of serious burdens imposed within it. The fact that existence benefits a person overall does not mean every imposed harm has been morally answered. This does not fully dissolve Heyd's concern. Future persons are still not ordinary, existing claimants, nor does it give courts an easy formula for deciding every case, but it blocks a convenient escape. We cannot say with confidence that future people have no complaint merely because their lives remain worth living. Climate change therefore presents two pressures at once. Heyd warns against treating possible people as holders of ordinary claims. Shiffrin warns against treating beneficial existence as a moral permission slip for serious imposed burdens. Climate litigation has responded largely by shifting the ground of argument toward people who already exist and already face environmental danger. In Heyd v. State of Montana, decided at trial in 2023, 16 youth plaintiffs challenged Montana laws limiting consideration of greenhouse gas emissions. Their case did not need to rest solely on the claims of unborn people. The plaintiffs alleged injuries to their own present and continuing environmental interests. The Montana District Court held in 2023 that the challenged provisions violated the plaintiff's right to a clean and healthful environment under the Montana Constitution. In 2024, the Montana Supreme Court largely affirmed that ruling. The structure of Heyd is significant. The plaintiffs were not abstract stand-ins for all future generations. They were existing young people claiming that environmental policy affected interests they already possessed and would continue to possess. This is a more familiar legal form than a claim made exclusively for people not yet born. The same broad pattern appears in the contrast with Klima Senior Innen. There too, the applicants were living people concerned about present climate-related health risks. The European Court found shortcomings in Switzerland's climate action framework under Article 8. The legal question was not whether a hypothetical future person could establish an ordinary individual injury. It concerned existing applicants and existing rights. This does not make these cases narrow. Existing children, adults, and older people live through a changing climate over time. Their present interests extend into their continuing lives. A court can address climate danger without first resolving every philosophical question about the rights of those who do not yet exist. But litigation's practical solution is also a limitation. It secures a route through the problem by focusing on existing rights holders. It does not determine whether a policy can be unjust, even where no identifiable future victim can show that they personally would have existed under a better alternative. That unresolved issue returns when we ask whether injustice always needs an identifiable victim. The Intergovernmental Panel on Climate Change states in its AR6 Synthesis Report of 2023 that every increment of global warming intensifies multiple climate hazards. This gives the philosophical problem a concrete modern stake. Climate choices do not merely distribute abstract value. They contribute to conditions in which multiple hazards intensify. Parfit's argument puts pressure on moral theories focused only on harms to particular individuals. If future identities depend on earlier choices, then the familiar comparison between one person's actual life and that same person's better possible life may not always be available. That is the force of the problem. It is not that no one is harmed. It is that the grammar of individual harm may not cover every morally bad future. One response is impersonal ethics. Impersonal ethics evaluates outcomes by the overall quality of states of affairs, rather than only by claims of identifiable persons. On this view, a future can be worse even if no particular person within it can say they were made worse off than they otherwise would have been. That approach can explain why depletion remains objectionable. The conserving policy produces a better overall state of affairs than the policy that leaves later generations worse off. It can also explain why climate obligations remain serious, even when altered future identities complicate individual claims. But impersonal ethics changes the moral picture. It moves us away from the simple idea that wrongness always consists in violating a claim held by a particular person. Climate law commonly relies on duties to existing rights holders, even when the policy stakes extend across generations. Cases such as Klima Senior Innen and Heyd show why that approach matters. Existing people face real and continuing environmental danger. Still, the law's focus on existing plaintiffs may not exhaust the moral issue. Every increment of warming intensifies multiple hazards. Some of the people living with those intensified hazards will be identifiable rights holders. Others will exist only because this, rather than another path, was taken. The non-identity problem does not erase climate obligations. It asks what kind of obligation they are. Is climate injustice real only when an identifiable person can show that they were made worse off? Or can a society wrong the future by choosing a worse world, even when its inhabitants could not have been anyone else? Subscribe for more philosophy grounded in the problems that are already shaping public life.